Welcome to the official On the Mic with Law Student podcast, where we talk and discuss questions with the law students from recent classes. This show is your source for ideas and your next steps on answering questions. For today's episode, we have the questions on discretionary power. I am Anis Sofia Omar, a third-year student at Roosevelt University College of Law. And today's episode is sponsored by Google Docs and Canva Student Edition, taught by experienced lecturers, and network sponsored by Umobile, Digi, and not to forget Maxis Line. In this episode, we will have 3 sessions to discuss 3 different issues on discretionary power. Today, we are honored to have with us Year 2 students from the University of London that are currently studying law for our first sessions together, Yasmin and Ainin. Both of them are taking administrative law as their core subjects, and under the subject, they have the topic of discretionary powers. Thank you for joining us today. I want to begin this session with the focus on what is the first issue that arises when you see the question under the topic of discretionary power.
The first issue is whether the Minister for Housing and Local Government had taken into account relevant consideration in exercising his discretionary power.
Thank you for enlightening us on the first issue, Yasmin. So, from your lens as a student that learns the law itself, what are the laws involved under this issue?
Firstly, we need to know what is discretionary power. Discretionary power is the power which is exercisable in its discretion by the administrative authority, where they can choose between alternative courses of action. An official in whom discretionary power is vested has a range of options, and he exercises a measure of personal judgment in making his decision. In exercising this discretion, the authority must do it according to the rules of reason and justice, not according to private opinion, wills, and private affections, according to the law and not humour. This discretion is conferred in the area of subsidiary legislation. As example, a minister is vested power by the statute to make rules to carry out the purposes of the act. It confers a broad discretion on him to decide what rule he should make, but it must subject to the doctrine of ultra vires. Okay, next we will look to the doctrine of ultra vires. So ultra vires can be divided into 2, which are procedural and substantive. So the main concern under the substantive ultra vires is that the authority, in exercising its discretionary power according to and within the limits set by the parent statute. Other than that, under substantive ultra vires, the court have developed a broad doctrine of ultra vires, which is extended ultra vires, so that they are able to review the exercise of wide discretionary powers to some extent on certain grounds. This is to avoid the abuse of power. Next, one of various ways that abuse of power can occur is when the authority, while exercising his discretionary power, does not take into account relevant considerations that lying within the purposes of the statute concerned. So, in Somerset ex parte viewings, consideration can be divided into 2, which is firstly, mandatory relevant consideration, which are being expressly or impliedly in statute, and secondly, discretionary relevant consideration, where authority may consider if appropriate. So if the statute lists down the relevant criteria which must be taken into consideration in exercising the given power, then the task of the court is relatively easy. In such cases, they have only to assess whether considerations stated in the statute have been applied. However, in such cases where the statute does not mention the considerations, the court may look into the purpose, tenor, and provisions of the statute, assesses whether relevant considerations have been applied by the authority in making decision. There are few cases that we can refer to. The first case is in Pengarah Tanah Galian Wilayah Persekutuan and Sri Lempah Enterprise. The applicant was a registered proprietor of a piece of land held in the perpetuity. He applied for conversion of land to the federal government. The authority concerned informed the applicant that the conversion would be approved if with the condition that he must surrender his freehold title, and in return he will be given a leasehold. The authority did not consider the conditions for conversion of land use given by National Land Code. The court held that the decision was invalid as the authority had not taken into account relevant considerations, as he ignored the procedures stated in the National Land Code. Another case that can be referred to is the case of Haji Sazali, where in this case the court ordered the applicant who was accused of being a drug addict to spend 2 years in a rehabilitation center. So the applicant sought an order questioning the magistrate judgment, claiming that he had failed to consider the report as required under Section 6, Subsection 3 of the Drug Dependence Act 1983, as well as Section 6, Subsection 4 of the same Act. So the magistrate's order was later invalidated by the court under Section 6, Subsection 1, Paragraph A, because he failed to consider the relevant factors. The relevant considerations were laid down in the statute, but the decision maker ignored them. Lastly, in the case of Associated Provincial Picture Houses Limited and Westbury Corporation, Westbury Corporation had jurisdiction to open cinemas subject to such conditions as the authority see fit to apply under Sunday Entertainments Act 1932. So the corporation ruled that no child under the age of 15 be permitted to movies on Sundays, regardless of whether or not they were accompanied by an adult. So the Associated Provincial Picture Houses filed a judicial review petition claiming that the ruling was unconstitutional and unreasonable. So Lord Reed ruled that if the nature of the subject matter and the general interpretation of the Act make it clear that certain elements are irrelevant to the issue at concern, the authority must dismiss them.
That is such an insightful take on the law that can be applied to the first issue. To get a clearer view, I think the listeners and I wanted to know how to apply the laws. How do you apply it, Ainin?
From my view, in applying the law into the situation, we can see that the Minister for Housing and Local Government has not taken into relevant consideration. Firstly, this can be seen when the Minister failed to take into account Manisa's intention, which is to build a resort centre using her own land. So this fact is the same to the case for pengarah tanah galian wilayah persekutuan against Sri Lempah Enterprise, where the decision will be invalid because the authority ignored the procedure involved in the process of conversion of the land used under the National Land Code. The same can be said to our current situation, where the Minister for Housing and Local Government failed to consider the process involved in conversion of legal whole of a land, because the decision that was made illustrates that the minister told Manisa that she must surrender his freehold title, and in return the application will be approved. Secondly, the minister had failed to consider relevant consideration when he refused to consider another inquiry as applied by Manisa, because he does not want it to become any political issue. Here we can understand that the minister has failed to look and refer to the sentence of the Act itself, because according to the Land and Development Act 2013 fictitious, the minister can put any inquiry he thinks necessary, and this includes when the first inquiry cannot be fulfilled by the applicant, or the applicant made application for another inquiry to be held. According to the case of Haji Sazali, the statute had laid down the relevant consideration, but the decision made failed to follow the statute. Therefore, the decision was quashed. The Minister for Local House and Land Government should have given another inquiry to Manisa, because the Act itself states that he can impose any consideration necessary before giving approval. By refusing it, the minister's decision towards Manisa is invalid, regardless if it is his way to avoid political issues. We can surely say that the minister should be required to think about his decision again by taking into account the intention of Manisa's application, which is to build a resort centre, which is a good intention because it will help her to increase the value of her land. I would like to add another case, which is the case of Associated Provincial Picture Limited against Witnessbury Corporation. The authority should have regard to all relevant considerations and procedures before making decisions so that the result will not offend any common sense. Taking this into our situation, the Minister for Housing and Land Government must not act like a dictator and do what he only wants by does not consider Minister's intention and application for second requirement. So, it is clear to us that the Minister for Housing and Local Government had failed to take into account all relevant considerations before making a decision.
That is such a wonderful take on the application from you. We'll be right back for our second session. We are hearing the answers from our two second-year students from University of London Bachelor of Law. See you in the second session.
Alright, now we are currently with the students from the University of London in Bachelor of Law. Let's move on to the second issue that arose. Anis, as for you, may I know the issue that you would like to state?
The next issue is whether the minister had taken into account irrelevant consideration.
Oh, thank you for enlightening the second issue, Anis. Now, is there any case of law that you would like to share with us?
Irrelevant consideration happens when a decision maker takes into account considerations lying outside the scope of the statute concerned while exercising discretionary power. The effect of taking into account irrelevant consideration is the action or decision made would be invalid. In the case of Regina against Secretary of State for Social Services, Wellcome Foundation Limited in 1987, Wellcome Limited were the manufacturers of pharmaceutical products including Septrin in the United Kingdom. The same product was also manufactured by the applicants in a number of other member states of the European Community and marketed as either Septrin or Euseprim. Wellcome Limited claimed that the marketing of such products in the United Kingdom under the name of Septrin without your permission was a clear infringement of their trademark. Wellcome Limited wrote to the Department of Health and Social Security asking that trademark considerations be taken into account when dealing with applications for parallel import licenses, but the Department of Health and Social Security replied that it was doubtful whether the fact that a product license ought to be in the name of Euseprin rather than Septrin was a ground for refusal of the license. The Department of Health and Social Security also believed that the disputes about trademarks are excluded from the assessment. It was sought by a Wellcome Limited for a judicial review whether a declaration that infringements of trademark rights were a relevant matter for consideration in the exercise of the powers to grant parallel import licenses. The court held that the decision amenable to judicial review cannot be affected by the failure of decision maker to take account of irrelevant matters or irrelevant matters. Another case of irrelevant consideration is in the case of Minister of Labour against National Union of Journalists. In this case, a few allegations were made against a reporter of Utusan Melayu for misconduct while he was in Tokyo for a fellowship course. The reporter defended himself by saying that the allegations were false. However, Utusan Melayu demanded him to write an explanation towards the allegation. Then, he was later suspended. As the letter of explanation was pointless to him, because Utusan Melayu had already jumped into conclusion, the newspaper company then dismissed him on the grounds of failure to explain allegations made towards him through a letter. Initially, the respondent stood on behalf of the reporter and furthered the case to the Industrial Relations Office, but since the conciliation process failed, the case was referred to the minister. The minister opined that it was not convenient to refer the case to the Industrial Court due to some political reasonings, since he had already considered all the relevant documents and he was satisfied that the reporter had been dismissed justly. The High Court delivered that the minister had crossed the line over his jurisdiction to decide that the reporter was dismissed with just cause and excuse. So, the minister appealed, but it was dismissed by the Supreme Court. Here, the court held that the action of minister was not valid as he took an irrelevant consideration into account.
Thank you, Anis, for the great explanation on those cases of law. Now, moving on to our next guest, Atira. Would you mind sharing how would you apply those cases into the situation given?
Alright, thank you. I will start my application by the situation in this question. In this situation, the Minister for Housing and Local Government is empowered to consider any application to develop land as a resort centre. Thus, this power allows him to impose any conditions which he thinks are necessary before granting the approval. It can be seen that he imposed the condition that Manisa should surrender the freehold title of the land for that of a leasehold as he thinks is necessary. Then, it will be the problem if Manisa disagreed and be the reason her application was rejected. Moreover, the minister refused to hold another inquiry, and this action was made by taking irrelevant consideration when he actually should exercise his power according to the Land and Development Act 2013. He refused to hold another inquiry as provided for in the Act, which is out of the scope of his discretionary power. This is because he did not want the matter to become a political issue. Ignoring relevant considerations or taking account of irrelevant ones may decide or rule unreasonable in accordance with statutory policy. It can be seen in the case of Regina V, Secretary of State for Social Services at Spark Wellcome Foundation, that it is a reviewable error either to take account of irrelevant considerations. Moreover, in the case of Minister of Labour v National Union of Journalists, the power needs to be exercised taking into account the consideration mentioned in the statute. It means that he cannot just simply refuse to hold another inquiry as provided for in the Act. In conclusion, the action of the Minister of rejecting Manisa application by refusing to hold another inquiry as provided in the Act was invalid as he took an irrelevant consideration into account. That's all from me, and thank you.
Thank you for sharing your thoughts on the application with us, Atira. Alright, next, without any further delay, let's move on to the final session for our podcast today.
Welcome to session 3. Now we will discuss the third issue on discretionary power. Hannah, what are the other issues that you think we should discuss based on the situation given?
The third issue that we should discuss is whether the Minister for Housing and Local Government has made a fettering discretion.
Thank you for enlightening us on the third issue, Hannah. Can you please explain to the listener on what is fettering discretion?
Fettering discretion can be explained as a situation where the authority has failed to apply his mind in administering his discretion. This happens when the authority stipulates a policy to control the exert of the authority's discretion and attempts to employ the policy rigidly to all proceedings that came for findings regardless of the individual case merits.
Thank you for the brief explanation on the definition. Is there any case of law that you would like to share with the listener?
Yes, the principle of fettering discretion is illustrated in the case of H. Lavender and Minister of Housing 1973, all in a report 871, where in this case the government embraced a policy to preserve good agricultural land for the means of agriculture in opposition to gravel working disruption. The Minister of Housing, who was empowered to permit minerals extraction, had rejected the petitioner application of consent to extract minerals from an agriculture. The rejection was made due to the objection made by the Minister of Agriculture on the grounds of agriculture. The court held that the rejection to give consent for the minerals extraction made by the Minister of Housing on the ground of disapproval by the Minister of Agriculture was held to be a fettering discretion. And also, the Minister of Housing is said to have unlawfully transferred his authority of discretion to the Minister of Agriculture. The Minister of Housing's edict was rescinded on two reasons. Firstly, the Minister of Housing employs the policy rigidly. Secondly, the Minister of Housing has transferred his authority of permitting extraction of mineral to the Minister of Agriculture, who is not empowered with such authority in decision-making relating to permitting extraction of mineral.
Thank you for the short and simple explanation on the case law. Can you please explain to the listener on how will you apply this case into the third issue?
In applying the case of H. Lavender and Minister of Housing, 1973, All England Report 871, in this case, the rejection to Manisa's application to develop her land into a resort centre made by the Minister of Housing and Local Government was a flattering discretion. This is because the decision of the Minister for Housing and Local Government in rejecting Manisa's application is influenced by the objection made by Minister of Science and the Environment. Since the Minister of Housing and Local Government is empowered with the authority to consider any application to develop land as a resort centre under the Land and Development Act 2013, the Minister of Housing and Local Government shall exercise the power by himself, and the Minister shall not delegate his authority to another person. However, in this case, the Minister of Housing and Local Government has unlawfully delegated his authority to consider any application to develop land as a resort centre to the Minister of Science and Environment. The decision made by the Minister of Housing and Local Government is invalid on two grounds. Firstly, the Minister of Housing and Local Government has employed the condition rigidly in which the Minister of Housing and Local Government refused to hold another inquiry for Manisa's application. Secondly, the Minister for Housing and Local Government has unlawfully delegated his authority to consider any application to develop land as a resort centre to the Minister of Science and Environment, who under the law did not have any authority in matters of application to develop land as a resort centre. Therefore, the Minister for Housing and Local Government has made a flattering discretion.
Thank you, Hannah. That was a great application from you, and thank you for joining us. After listening to all the explanations on the three issues, we can conclude that Manisa may challenge the validity of the decision made by the Minister of Housing and Local Government on three grounds. Firstly, the Minister had failed to take into account all the relevant considerations. Secondly, the Minister had taken into account the irrelevant consideration. Lastly, the Minister had made a flattering discretion. Thank you for listening. I hope you enjoyed this episode of On the Mic with the Law Student Podcast. I would like to invite you to subscribe to our podcast on Apple Podcasts, and you can also reach us on Instagram at On the Mic with the Law Student Podcast Official. That's it for now. I am Yasmin. Thank you for listening.